Y'all, welcome to the stream. Baby Squid is not going to bed very easily, so she is going to be here for a little while. We will see how this goes. It's been quite the day. It's been kind of a disheveled day. So she was just in bed. I was about to start the stream, and we did not go back to sleep. We started crying, and here we are. So say hi. Say hi, cutie pie. So we're going to get right into this. Sarah Boone had a hearing today, and unlike most of them that are recorded and then posted later, this one was live. Did not watch all of it. So we are, Roy, we see who won the bedtime game. It was not me. But she was also crying before bed because she bit me and I was not happy with her and I yelled at her and she was not happy with the fact that she got yelled at. Big shocker there. We are going to get right into this, and as always in this setup, I have my iPad here. So since I'm on my laptop, I will have the chat on my iPad so I can see y'all. We are going to get straight into this because it is an hour long. So I will start. Hey, Christine. Hey, Jingleberry. Cynthia, as always, Flash fan. Y'all are awesome. I love you, every single one of you. Let's do suitcase murder. And then we're going to make it full screen. Maybe. Come on. There we go. And start it up. And we are not exactly sure how long into this. Oh, please don't give me the screen of death. Judge Kraynick is on fire. Let's get to the point. I loaded it. I just didn't get to the point where we actually got to view the hearing. So if she starts to fall asleep, I'm going to get going and I'll leave the hearing on and I will just let y'all watch it while I go put her to bed. But we'll see how that goes. Hey, Unknown Hero. Nice, Christine. Congratulations. 200. I am hovering around the 470 mark. I go up to 470. I go down to 469. I go up down to 468, back up to 470. I don't exactly know what's happening. So I just can't see. Yeah. Go sleep. This will be the first appearance of Sarah's new lawyer. We will see how he handles his client. Let's go sleep.
Oh. Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience.
Thank you.
Thanks.
Oh. Christine, because I'm out of my element and I only have one monitor and things are weird, I'm doing things by myself for now. But eventually, yeah, just I kind of have a straight to the point. Let's get this done. I gotta get her to bed. Just okay. I wasn't sure how far into it that they got to Sarah's case. So we're going to skip ahead. Oh. And everybody is getting sick up here. So the fact that I was sick before I even got up here, and now I'm super sick. So it's a work in progress trying to get my health back. DJ Radis. Yes, Jingleberry. Baby Squid chose chaos. That's our everyday. We know nothing but chaos in this house. In time. How are you, DJ Radis, and how are you with the have you been served yet? Oh, that drama. I can't even believe that crap. There's our infamous suitcase Sarah. Oh, that smile. Oh, that evil side-eyed smile. Ugh. How? Hey, Nanny Goat. Yeah, she knows the camera's on her. And fair enough.
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. Clerk's going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute, he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that.
Okay. I'm sure most of you have heard this already and caught this, but they're going with the battered spouse defense, which I believe other lawyers have tried and abandoned. So I'm curious as to how he's going to make it work. Also, I got to give this guy credit where credit is due. This guy actually somewhat knows the case and the background of the case. He knows this case better than Gingras knows Laura Owens' case when he took over and actually went to court. So I got to give credit where credit is due. I still don't think he entirely understands what he got himself into. However, he's doing a better job than Gingras was on Laura Owens' case.
She's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I push them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, Counselor, when I was prepping last night was the motion for statement of particulars.
You filed it.
I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have your motion for statement of particulars filed 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, the other 3 aren't. They were all filed yesterday, 19.
No, certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response following August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes,
and I've spoken with Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to the council?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Mr. Owens?
Office in the building?
Yes, it's in the courthouse.
Right there. Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state give the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. How much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th.
Hey, Tammy.
And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, state, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing defense. And there's a second doctor, Dr. Michael Brandon. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marcia Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
Okay, I understand that everybody's entitled to a defense. I really do. However, most everybody has seen the video where she is drunker than a skunk and he is begging. If you're in imminent danger, you don't do that. You call the cops and you have the cops handle it. Hey, I got him in this suitcase somehow. He's threatening to whatever. Handle this. You don't taunt him and basically watch him expire. I understand that everybody's entitled to defense, but this lawyer it's a stretch. In my opinion, it's a stretch. Juries are weird, but it's a stretch.
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for forensic psychologist. Two forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Torres involving the apartment complex, which is in Winter Park, that was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
the JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs, since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right.
Grandpa took her.
That takes us now
You're gonna
then to your motion for continuance
Grandpa's
file
number.
that was filed on August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it. It is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially The motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times.
You've spent 3.5 hours with her on one day, and I don't think any of this is in good faith. The more he talks, and I understand he has to try, but the more he talks, the more I think it's complete bull crap. And as Flash Fan said, he's done interviews, which we will get to after this hearing. But I don't think he's, but anybody that can make her creepy ass smile like that freaks me out.
I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim. And I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure.
Okay, my next issue. He mentioned that one of their experts has been on this case before. Why do you need 6 months to prepare if your expert has already been on this case and knows this case? To get a neuropsychologist report takes about a day. It doesn't take long. This case has been all over the news and everything's been public for 4 years. You would have think before he took the case, he would look at it and see everything that's there. And I understand it's probably not in depth. However, sorry, Rogue.
Sure, the state's going to want to take a position. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff's department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could. But
He not only took this case, he traveled for this case. He is not from Orange County. So he just wants fame.
But not without better spousal tips, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys. And in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can file that in good faith. I can't do it.
And that only takes a day or two.
She needs more time. Dr. Brand needs more time.
All right, thank you. State, anything else?
No,
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in a judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You have been appointed in this case. When you undertook this assignment, knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the...
Okay, he said he's doing this pro bono, not seeking any money. He's seeking fame and thinking that he's going to get more clients. And I guarantee you there's a book in the works. I guarantee it. He's trying to get famous before he retires. Nanny Goat called it. He knew what he was getting himself into. And judge is laying the smack down. I love this judge. We had 3 examples, and I brought this up in Mo's chat earlier. We have 3 prominent cases from Florida. We have Sarah Boone, Maya Kowalski, and Jeremy Hales. 2 of the 3 judges are eloquent, knowledgeable, and patient. One is not.
Deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020. Under Mr. Padilla's representation of Ms. Boone, at no point in time did Mr. Padilla file a Category A witness list, disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who had expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the 4 Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those. In Roberts versus State, 75 Southern 3rd, 1277, and pinpoint 1281, by the 4th DCA in 2011, citing to Lawson v. State, 84 Southern 2nd, 540, also by the 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the
16 times. 16 times. 16 times. Let's just let that sink in for a minute. 16 times. And not all of them were for lawyers, but 16 times. This is her fault. And this lawyer, I understand he has to try. He has to give it his all. But he knew getting into this that the judge said will not be continued for anything. And here he is trying to come up with something. It's in bad faith, in my opinion.
The date of your filing of your notice of appearance on August 30th. This case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in terms of the state 311 Southern 3rd 185 and 10.189, 42nd DCA 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial.
Last time I will. I'm working on getting the channel.
Trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I have 12 clients that are pending. I've got a meeting covered, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion, then provide a form order, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're originals, but I'm going to need to look at that. I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume is being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
I kind of agree with that. I can't believe I just said that.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall follow a court notice reflecting the discovery in the USB jump drive, which contains the state digital evidence was provided to Major Malik X. Muhammad at the Orange County Jail, according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
Hong Hero, I still don't think she actually thinks she did anything wrong, ever. Like, even being pro se, like, I still don't think that she believes that anything is wrong. She's always in the right. Sarah's always right, and the world is always wrong. That's the way her mind works. But here's my thing with this. I do not like this attorney. I don't hate him. I don't like Gingras. But he's more bullish than the other ones. I think he's out for fame, so he's going to be like Richard Gere's character in Chicago. Very boisterous, very talk to the media. But with this extending the deadline to file an objection to any of the state's evidence, I think he should get like 3 days. Like, you don't need till a week before trial. You need 3 days, get over it. You're late to the game. She was pro se. She could have filed objections. Any of her other attorneys could have filed motions, but nobody did. It's been 4 years. Suck it up, Buttercup.
I'm going to be amenable to setting a status hearing that week.
Here's what we're gonna do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
Give me 1 minute.
Sure.
No one here, you are right. Her actions did cause it, but I don't think that she believes that her actions caused it.
State anything else?
Not this time, Your Honor.
Madam Clerk is gonna work dutifully to, it's already done. Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Excellent.
Can I have a word with Sarah?
Absolutely.
What did he just give her? Anyway, so that's that. We're going to get rid of that. Oh, that's Sarah. It's good old Samsonite Sarah. So there's an extension of time for the viewing the state's evidence. The trial is still going on October 7th, despite his best efforts. I believe he just wants fame. I don't think, what was his name? Billy Lane or Billy something, the character, Richard Gere's character in the movie Chicago. That's what I think he's doing. His client's still going to go to prison, in my opinion. A jury is not going to buy any of this crap. 4 other attorneys tried it and obviously let it go because it was not working. And he's going to be the one who magically makes it all work. So Flash Fan sent me a video. I think my dad's trying to put the little one to bed. This should be interesting. Hopefully she's already asleep. And Flash Fan, I'm looking for the email. It's weird on my laptop because everything's small. So I'm like, let's try this one. Come on. And everything is just taking, I'm very, very, spoiled with the setup I have at home. And for as new as I am to have that much, 2 monitors and a mic stand and all that, and being on the road with my laptop, I'm like, where is stuff? I haven't used my laptop since I got my new computer. So it's definitely I'm spoiled, and it's something to get used to. So should be an article. There's this one that you sent me. So we'll watch this one because I haven't had the time to go through any of these things because of
news from Fox 35.
Because
Watch breaking news, weather forecasts, politics, and more on-demand content.
So we're skipping his. There we go. Ah! See, this is what happens when I'm allowed to touch things. So we're gonna close that, stop sharing, and I'm gonna reopen it because There's a delay. Yeah, that's it. Okay. I'm going to reopen that because I hit one too many buttons and skipped to the next video. So we're just going to close it and reopen it because, that's just how I roll. Present, share screen. There we go. Oh, I'm sorry. We don't need a Fox 35. Good day, Orlando. Sorry.
Day Orlando.
There we
You can
go.
depend on me.
So why
Thank
this
you.
case?
Excuse me?
Why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration. Okay, this just a gap in the system that hardly ever happens. On the federal level, on the state level, everybody charged with a crime is entitled to counsel. Okay, everybody, never unless the defendant waives their right and wants to represent themselves, which is rare and foolish. But I understand the judge's ruling. We respect the judge's ruling, but that left Sarah in a position where she's standing in a courtroom accused of murder without a lawyer. I can't think of any other time that you would need one than in that scenario. So once that decision was made by the court, Sarah put an ad out. Somehow it got on court TV. I watch a lot of YouTube, true crime. I saw it.
Maybe he's watched some of this.
I waited 3 or 4 weeks thinking that one of the members of the defense bar here in Orlando would pick up the torch. 3 or 4 weeks went by. It did not happen. I had another case down here in Hillsborough County in Tampa that I had to come down for. So I wrote her a letter about a week before that. And she had a third party, a girl from Minnesota, that reached out to me, I think first just to see if I was legitimate. They said to see if I think catfishing is what they thought I was doing, somehow, some fraud. I think once the third party realized that I was genuine, then Sarah.
He does not watch me,
we talked
but he watches YouTube
a couple of times, and I said, "Hey, I'm coming down that Wednesday for that court case in Tampa. Why don't I just come down Monday?" Which I did. I got done with court, I think, Monday at noon. I drove down 6 hours, spent the night, got up the next morning. I think that was on the 20th, and I spent about 4 hours with Sarah Boone at the Orange County Jail. During that period of time, I was in talks with the prosecutor, let him know what I was doing. He wanted me to file a notice of appearance. I wasn't ready to make that commitment yet. Didn't do that, but I got Sarah to sign a document essentially saying, you can speak to the prosecutor on my behalf. There was attempts to try to resolve it. If we would have come to terms, I would have filed the notice of appearance. We would have set it for court, set it for hearing, and the case would have been resolved. So we did make attempts like everybody does in every case. Any prosecutor, any criminal defense lawyer, public defender, you have plea negotiations.
Does anybody know what those plea negotiations would involve? Or what? I know Sarah is never going to take a plea deal because she's Sarah, and she once again, she never does anything wrong. It's the world's fault. It's everybody against Sarah. Those narcissistic personality traits. But damn, I really want to know, to be a fly on the wall in that room.
That's just part of it. So there were attempts to settle it. I was kind of like a mediator. I was kind of like a go-between, because once she became pro se, it's very difficult for the prosecutor to then communicate with the defendant. Actually, the rules say you got to do it on the record. And you can imagine not having somebody to negotiate for you, and she's trying to negotiate with the prosecutor, trying to send her to prison for the rest of her life. So somebody had to do it. I was doing it. But after those, so I met with her that day. I went over to Tampa, handled my case. I think I was done at 2:30. I came back. Well, Billy Lane, the investigator that's assisting Sarah Boone, pro se, he had scheduled an appointment to meet with Sarah that night. So I went back over to the jail. They let me meet with them. So the three of us met.
This was, I think, the 21st, like it's set from 7 to 8:30. We met for about an hour and a half. And, at that point, we couldn't reach an agreement. And then I wasn't ready to represent her at that point. I immediately told the prosecutor that there was an impasse, there was no agreement, that I was not going to be representing her. I got in the car and drove back home, got home about 4. I had court the next morning at 8:30. I was done with the case. I did the best I could. I want to say 2 nights later, my wife and I were home and Sarah called and we talked again. Of course, I was still thinking about it, what to do. And, but I told Sarah I still was not committed to doing it. That was on like the 23rd. Well, then that third party called a day or 2 later, and really nice lady that I really respect. We developed a relationship, and she asked me if I would go one more time. So I flew back down. We met again a couple of times. I can't remember the dates now, 25th and the 26th. But both meetings went well. And you got to understand, Sarah's been through 8 lawyers, so there's some trust issues. And on both sides, I'm concerned, is she going to try to fire me, or we're going to have problems the same way, as you can imagine. But, I like her. She likes me. We communicate well.
Creepy.
I think we're both on the same page. And, I spoke to my family, my wife, my daughter Sarah about it. Sarah's thinking about law school, so I got their blessing. I have, some colleagues that I practice law with, a law group there in Milton. And obviously it's going to take some staff to pull something like this off, especially knowing that the judge, I was in hopes he was going to continue it and give me 2 or 3 months. He did not. So we've got about 30 days. So I'm going to have some help.
I'm not going to lie. If he would have continued it, I would have been happy, because my schedule between now and the end of October is incredibly crazy with appointments and stuff. I will be streaming this trial with Mo, but we have to kind of figure out how we're going to do it. But I would have been okay with a continuance, not going to lie. I knew it wasn't going to happen, and I appreciate the judge's firmness on that. But the back of my mind, I was kind of hoping for like a month. Just push it back a month. Let life kind of settle down, and then we'd be all right.
From the staff, but we're trying to assemble a team right now. I've got a couple of friends that are lawyers that have indicated they're going to help me. And what are friends for?
Are you doing it pro bono?
I've been retained. I'm not doing it pro bono.
She promised him commissary.
Sarah owes me. Sarah owes me.
Can you speak a little more to your plan for defense about the battered spouse syndrome?
Well, I'm not an expert, but I don't know if we're going to be able to do that, because we're time crunched now. As you know, I think y'all understand the rule now. We've only got till the 9th, which was today, the 3rd. We've got 6 days. So I'm going to try to pay for Dr. Julie Harper to fly down here later this week. She's actually from my area. The 2 experts that I had asked for, well, there's a third one, but 2 of them are from my area. Dr. Harper's from Okaloosa County, and Dr. Berkman's from Escambia County. But I've been in communication with Dr. Harper. I think I'm going to get her to fly down here later this week to meet with Sarah several times. Hopefully, at the end of those meetings, like I said, she's already met with her, but it was 2 years ago. She met with her 5 or 6 times. Hopefully, she's going to agree with me that she does suffer from battered spouse syndrome. And so then if she's able to give me that opinion by the end of this week, my intent is to file the notice with the court and the clerk of our intent to rely on that defense. And then we go from there. That's
okay. He doesn't seem like that bad of a person. I'll give him that. Like, would we be besties? No, but would I have a beer with him? Probably. However, When he said, I like Sarah, she likes me, that is bizarre to me. Bizarre. But to each their own. However, is he the one person on the planet who has never seen the video of her taunting him in the suitcase? He has to be the one person on the planet who's never seen that video. Because that takes, in my opinion, I'm not a lawyer. This is not legal, medical, personal advice. This is just my opinion because I do me. If she would not have filmed that, this might stand a chance based on their previous history. But Sarah decided to whip out her cell phone like a millennial or a Gen Z instead of a Gen X, like she is, and film it. Film her taunting him. I said it earlier, I'm going to say it again. If you are a battered wife, you somehow got him in a suitcase, you call the cops and say, I'm scared of this dude, even though he's smaller than me. Figure that one out. You call the cops. You don't taunt him and watch him expire. That's not a battered wife. That's a conniving sociopath, in my opinion. But to each their own.
That's really all I can say. It's up to Dr. Harper, not me.
So you've got 6 days to do that. Now, barring a Matlock miracle and that doesn't occur, what is your other, I guess, plan of action?
Well, Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case.
You think?
There are some explanations. I'd rather not get into my other potential defenses, but we do have some defenses. They've got to convince the jury beyond a reasonable doubt. That's all I really want to say. Just like any other lawyer facing a trial on a criminal case, the state has the burden. We're going to test the state's evidence, and then we've got potentially a case to put on. But we'll see. We'll see what happens at the end of this week. It'll be interesting to see if we can utilize, because I do believe she meets the criteria just from everything that I have viewed in terms of Mr. Torres's prior arrest. I did want to say something else, but I want to say something, but I'll wait for you. If you got to
move downstairs.
Okay.
Or, we can just wrap it up.
We can just wrap it up.
I did want to say this. The Torres brothers are violent towards women. I'll say that again. The Torres brothers, George and Farrell Torres, are violent towards their women. Farrell Torres is George's brother. Are y'all aware of this? He was arrested in May in Seminole County for killing his girlfriend, the mother of his children. He stabbed her to death. I've got the file right here. He called 911. Eventually, the 911 operator got around to, where is the weapon? Where is the knife? It was still in her head. I don't know. Sarah's told me about the family, the dysfunction. I seriously doubt that's going to be admissible in my trial. But there's two sides to every story.
There's 3 sides to every story. Your side, my side, and the truth. But Flashman sent me the article. We're going to read it. However, just because you're related to a murderer doesn't make you violent. And I don't doubt that they had issues in their relationship, Sarah and George, but it was from both sides, not one-sided. They were both arrested previously for DV against each other. So it's not a one-sided thing. But we are going to read that article shortly.
And Sarah's got a story to tell. I think she's been mistreated to some degree. It's difficult to represent yourself. I wish you could just imagine you had a daughter that was in her situation where she's representing herself, or maybe a sister. Just for 10 minutes, just think about her situation. You know, she's backed into a corner, and she's the type, like most of us are, they're going to come out swinging. That's what she's been doing. Some of it is probably appropriate. Some of it has been inappropriate, but it's all she knew to do was to fight. And she's been fighting. She doesn't have to fight anymore. I'm going to do the fighting for her. So she feels good about it. I feel good about it. We want justice to be served. We feel like if we get a fair jury, that we got a good chance. That's all I'm saying.
Thank you.
Thank you.
All right. So here we go. Come on. Oop. Just doxed myself, but there we go. Oi. Flash fan, I don't know if part of me, he seems to have two personalities. Hey, Spawn Trooper. I was not aware of part-time squid were allowed to operate heavy equipment. That's hilarious. Oh, how are you guys? So this is the body cam of his brother. And Flash fan, this is all goes to him. He is the one who is doing all of, he's my research man. He does a lot of my research. I can't take credit for that, especially these 2 weeks, because it's been a hell of a 2 weeks. Like, I can't even visit with some of my family and some of my friends because I make plans and it's like, oh, this person got diagnosed with this virus, and so this person got diagnosed with this virus, and it's like, so it's like making plans, and like it's been crazy, and then trying to deal with all the grandpa stuff, and you know, it's I gotta go to the police station tomorrow and get the reports, because this town doesn't have their stuff online, and yeah. So anyway, we're gonna get back to this because then I can get to sleep, because I took my melatonin and now I'm about to pass out. So this is body cam footage of his brother. Come on. If my computer will play it, you know. You gotta love the ads. Audio. I wonder why you guys can't hear it. Oh, please, StreamYard, cooperate tonight. Please just cooperate, because, you know, let's try it again. And if not, I'll just read the article, because there is an article attached. We'll try this again. And it could just be that I have so many tabs open and I'm on my laptop, which we all know from when I first started streaming. only tolerates so much before it says no, it's done. So let's try to share this again. And it's not muted. I could hear it. It's just, y'all don't pick on me tonight. It's not the night. Yes, I was Navy, but just remember, SEALs are Navy. So if you really want to go there, we can go there. Let's see if it doesn't work this time. I will just read the article. Share. Let's try this one more time.
At Energy Today, we help make your to-do list a today list so you can conquer your day. Our team of trusted, reliable electricians are ready to help you with all your electrical needs. And right now, get $100 off any electrical service. Go to energytoday.biz to learn more.
Released body camera video shows the moments after police say a Seminole County man called 911 and told the dispatcher that he stabbed his girlfriend. Pharrell Torres is accused of killing the mother of his child. West Tucson Gabriel was in court today for the man's first appearance.
It's a homicide, first-degree felony.
In court Thursday, Pharrell Torres was told he would stay in jail without bond after his girlfriend, Vanessa Santiago, was found dead in her apartment. Body cam video shows what happened just one day before. Castleberry police found a sobbing Torres with blood on his hands at the San Jose apartments. They say it was after he called 911 himself to report that he stabbed his girlfriend.
You like that, right? Yeah, don't do anything stupid, okay?
I'm not. The arrest report says Santiago and her 2 children were living in the apartment together. Police say Torres is the father of one of them and that the children were not there when their mother was stabbed in the head. The scene so gruesome, it had to be covered.
No, she's cold. She's cold? She's cold. Yeah, no, she's on the head.
Castleberry police say this was not the first time they heard about the couple. Just 2 months ago, they responded to a call that said no one had been violent, so there were no charges. And then in 2021, police say the sheriff's office got a report about Torres being violent towards Santiago.
We're trying our best to help victims, and it's a matter of getting the word out there that there is help.
Jeannie Gold leads the Seminole County Victims' Rights Coalition. The group runs a Safe House of Seminole, a shelter for domestic violence survivors.
Our shelter, which has 48 emergency shelter beds, we were so full from January through just probably last month.
But she says nothing should stop anyone from seeking help if they are struggling.
You don't have to be a victim to call a hotline. You can call the hotline and say, hey, I know somebody. I want to help them. What can I do?
In Seminole County, Senega Brigadges, West 2 News.
And Torres is expected back in court on July 2nd. If you or anyone you know is a victim of domestic violence, please seek help by calling 911 or the national hotline at 1-800.
All right. So just because you are related to somebody who is violent doesn't make you violent. And also, like, I know that y'all hear me sometimes saying, I'm going to help Wolfram and Mo fire up the reactor for Lord Chippy. But just because someone might be violent towards you, or you might not get along with someone, they don't deserve to be unalived the way he was unalived. Like, I wouldn't wish that on my worst enemies. Well, maybe one, but that's neither here nor there. That's a story for when we get monetized, because I got stories. Oh, little tidbit for that before we're about to cut this stream short because I have to get to bed because I have an early morning. But I wanted to go to my old hospital and visit some of the people that I used to work with. And the friend who I'm in contact with, and I was supposed to see today, she was like, well, this certain person is working today, or tomorrow. I wouldn't go if I were you because it'll just be tense and, you know, all the problems you guys had. I couldn't remember this girl's name. Apparently, my name has been brought up over the past 4 years that I haven't worked there, and she still has a problem with me. She still has a problem with me. I couldn't even remember this bitch's name. When she told me the name, I was like, who? Like, that's how little this chick meant to my life. But apparently, I'm intimidating and I'm mean, and I had a really big impact on her life, and I affected her 4 years later. Holy fuck, lady. Holy fuck. Holy fuck. I live rent free in her head, apparently. I couldn't even remember this chick's name. Holy crap. Somebody's either completely emotionally damaged, or this chick also probably has TDS too, so there's that, but that's a different story. Flash fan, I will have, well, Veteran Nation, I also just don't take crap. Like, I don't, like, if you're being an ass, I'll tell you. Like, and I'm gonna defend myself from people being stupid. I kind of wanted to do that, but I was just like, it's not worth my time. Fuck them all. Like, but I finally found somebody more petty than me. I thought I lived in the pettyverse, but apparently, like, I looked at a picture the other day that somebody posted of all the people who like work on that unit. I recognized their faces, but I couldn't tell you half of their names because they didn't leave an impact. We weren't friends outside of work. I liked them at work, but I liked them at work for the most part. But like, we weren't the type to go out and have, they're all upper middle class white women who with, you know, high level degrees. That's just not my, like, no, none of them ever. We've been through different life experiences, putting it mildly. And yeah, so there's that. But like, I looked at this picture and I literally couldn't tell you half of these bitches' names. I don't know. Like, I don't, I have no idea who half of these people are. I was like, I know I worked with you a time or two, but like, I don't know who you are. Well, not all of them are created equal. Yes, but you're normal. You're normal. Like, E5. Holding it down for all the E5s. All right. I gotta get going. I gotta get to bed, and I'm really hoping that my daughter is asleep when I get in my bedroom. That is true. Well, normal's overrated, but you're my kind of normal. Like, yeah, it's you either, well, plus y'all, when my parents have both been in chat, my dad is stubborn and assertive, very assertive, and my mom is stubborn as all get out. So the combination of the two can be kind of interesting, to say the least. Normal. You're normal. All right. Y'all have a great night. I will see you guys tomorrow. WTF Wednesday will be 3 o'clock Central Time. Things are weird timing. Tomorrow's a busy day. Got 3 different people to see in 3 different areas of the county. So we're we're doing some. Tomorrow's busy. So I'm trying. Oh, did I hurt your feelings? Oh, do you need your safe space? All right, I'll see you guys tomorrow about 2 or 3 o'clock Central Time. I'm not sure exactly when. I'm trying to work out my schedule, but I'm also trying to stream on a regular schedule so that I have some sense of normalcy. Because I was getting in that every day or every other day streaming, and to not stream all week and to do other things and just stop, it's weird. Like, it's just weird. So I got to get back into some sense of normalcy. And I'm also trying to keep the little on East Coast time. So when we go home, it's we're not trying to go to sleep at 10:30 or 11 o'clock at night, because Mama can't take that. Mama wants to be in bed at 11. Flash Fan, I will play your song tomorrow. Flash Fan wrote a song about Sarah Boone, and I loved it. It was funny as hell. Yes. When I get back to Georgia and I'm in my own environment and I'm not in the Army Green Wells. So I'm in slate gray. This is my dad's office. His computer's right here. He's got another desk set up because he works from home some days of the week. And I'm taking over his space. So pleasure to meet you too. Glad to see you here. Y'all have a great night. I will see you tomorrow. Hopefully I won't look so disheveled. You're getting the sweatpants and flannel look today. It's the mom look. All right, y'all have a great night. I will see y'all later.